Our next item is another act on compliance, Rule 0240-07-06 and policy number 29. And I'd like to ask Jeff Farah, the Associate University Counsel, and Miriam Wilson, the Assistant to the President of Institutional Equity, to present this item.
Good morning. Everybody hear me?
Morning.
As you know, my name is Marion Wilson, and I'm the Assistant to the President for Institutional Equity and Compliance. I'm also the university's Title IX and Title VI coordinator. My brief task this morning is to provide a quick overview of Title IX and how it's implemented at MTSU, and then I will yield the floor to Mr. Farah so that he can discuss the proposed new procedures. As you know, Title IX is a federal regulation that's been around since 1972. It's required of all institutions to have a policy and procedures to address reports of sexual misconduct. Title IX is to assure that no person based on their sex or gender is denied any benefit or service or is discriminated against or harassed in educational institutions. MTSU has had a sexual misconduct policy and procedures for a very long time. The policy has evolved over time. As recently as 2015, the university updated our policies based on federal regulations. At that time, we had latitude in how that policy and procedure would be implemented on our campus. The proposed regulations that were released on May 16th, 2020, just 3 months ago, have become very prescriptive and do not allow the university to have latitude in how we implement the policy and procedures. The new regulations are specific and very prescriptive. There are a few commonalities. Some of those we will retain from the previous policy, where we had to identify who the MTSU Title IX coordinator is, the Title IX team. We've changed the name based on the federal regulations for the folks who are required to report incidences of Title IX sexual misconduct. Those folks will now be referred to as mandatory reporters. Previously, we referred to them as responsible employees. We also will identify in our policy where formal complaints are reported and the supportive measures, which used to be referred to as interim measures for someone who finds themselves in a difficult situation and needs assistance. Given the nature of these changes that are required by the Department of Education, we're proposing a dedicated Title IX policy that follows the federal requirements. Because the new policy relates to student discipline, it requires a rule and rulemaking process, and Heidi Zimmerman will talk about that in a short time. I will make one other note that in this past year, 2019-20, the university had 121 reports of some type of sexual misconduct on our campus. 16 of those led to formal investigations. Does anyone have any questions? I'll turn the floor over to Jeff Farah.
Good morning, everybody. My name is Jeff Farah. I'm the Associate University Counsel and have been working on drafting the new Title IX policy and the regulations that Dr. Wilson just spoke about. And as she mentioned, by and large, a lot of the things that we've been doing day to day don't change with the new regs. It's a lot of what's in the regulations we've already been doing. They're just giving more specifics about how we have to do them. For instance, with our prior policy, the regulation, or we've always performed an investigation whenever an allegation of sexual misconduct came in, always prepared an investigation report. The new regulations, however, now are very specific on what has to be included in that investigation report and what we can't include in that investigation report. So whereas previously we would include proposed findings, proposed discipline in the investigation report, we don't do that anymore. The investigation report under the new regs is purely factual. For another example, under the prior policy, everyone was extensively trained, either in person or through some online training. Under the new regulations, everybody's still going to be trained. It's just they've now specified precisely what each participant in the Title IX process, precisely what aspects they have to be trained on. And it's going to be for everyone who is participating at any level of the process under the new regulations. We've always provided the opportunity for a live hearing for a student who was found responsible or an employee that was found responsible for some form of sexual misconduct. This will carry over to the new regulations as well. But the new regulations put out this brand new, very specific hearing process that we'll now have to kind of pivot to follow. It's not a court hearing. In some ways, it's similar to court, but in some ways, it's very dissimilar to anything that happens in a court hearing. A lot of the rules will be similar, but a lot of the rules will be different than anything that actually happens in court. So the university is not a participant in the hearing. We're not taking one side or the other. Once the matter comes to a hearing, we're there to facilitate it. We're there to make sure that they have a space to conduct the hearing. We're there to make sure that the technology is available to conduct the hearing, making sure that university employees that may be witnesses or needed as witnesses are there and able to participate as witnesses during the hearing, making sure there's a hearing officer that's there to actually adjudicate the hearing. And at the end, we're there to make sure that each party, both the complainant and the respondent, that their rights throughout that process are being respected. Under old policy and the new regulations, both the accused and the accuser have equal rights throughout the process. They have equal rights to supportive measures. They have equal rights to have advisors present during their meetings with the investigator or during the hearings. They have equal rights to review the evidence. They have equal rights to review the actual final investigation report that's been completed. They have equal rights to cross-examine and to present evidence at the hearing, equal rights to appeal a decision. So everything, as you go through this process, everything that's available to one side is by and large going to be available to the other side. So the end goal of both the policy and the rule is to maintain kind of that level playing field that we've had between the parties, but to do so kind of under the rubric of the new Title IX regulations. Does anybody have any questions?
Go ahead, Tom. I'm sorry.
Just one question on page 33, letter E
Okay.
on that page. And it states that an interim suspension of student notwithstanding the above, MTSU may respond from MTSU's education program or activity on an emergency basis with or without a grievance process pending. And this may be in here somewhere. So the question is, would that be upon advice of counsel if they're removed without a grievance process? Is counsel consulted before that would be done? Our counsel?
Yes, our office would be very intimately involved. And when it says without a grievance hearing, that is without the full hearing after investigation. There is still a right to a hearing if, for instance, if a student is interim suspended as a result of some serious allegations of misconduct and there's a determination that there's a safety issue and they're interim suspended, there is a right to a hearing. And I can't remember the precise number of days, but very quickly after that decision has been made, that only decides whether the criteria have been met for that interim suspension. And then, so that'll happen no matter what within a few days afterwards. And then you go through the investigation process and the formal Title IX hearing process. So in that case, you would have two hearings, actually, one on the interim suspension only, one on the sexual misconduct.
I just want to make sure counsel is
Yes,
engaged.
and yes, sir, we're very involved.
I've got a couple, not any of the big issues, because I'm okay. I promised. But two things. On page 17, 72 hours prior to a live hearing, both parties get written notice. And my question, not for you to answer, but to consider before we vote on it as a board, is that enough time? That doesn't appear to be enough. If I had 3 witnesses in 72 hours and I was going on a baseball trip, I might get the notice. I don't think that's enough time. That's on 17, number 4.
Number 4.
That's not a deal breaker. I don't see what's wrong with having more time there.
Shows us page 9, but page 17.
Page 9.
Depends on which one
It's
you're looking
9
at.
and page 17. I'm just not sure which one.
It's page 17.
But it has a 9 in the middle of it
Oh,
at the bottom.
Number 4, the fourth item down.
Well, I'm asking you to
least-
look at that for the next, before we vote on it. It's not really, I don't want to debate it. And I think I know this, but I want to make sure. So we chose preponderance of evidence, and that suits me, but we chose that for both faculty, students, tenure, whatever the complaint might be. If a faculty member's charged, if he's found guilty, it'll be preponderance of evidence.
Yes, sir. It's preponderance of the evidence across all classes
Okay.
of respondents.
That's what I thought. I just want to make sure and just for the record, both parties, the accused can have an attorney, and if he doesn't, we're going to appoint a representative, right?
The regulations require us to provide, during the hearing, you provide an advisor to the parties. If they can bring their own if they want to, if they have an advisor. If they don't have an advisor, we provide an advisor for them for the hearing for the purpose of conducting cross-examination.
And the advisors will be of equal competence.
Yep.
I mean, no two people are equally competent, but if the accuser has a lawyer, then accused has to have a lawyer.
Well, the option is there. I mean, we say the university will provide an advisor, and advisors can be, but don't have to be an attorney.
Okay, but if the university funds an attorney for one, they'd fund an attorney for both. Or if they don't fund an attorney for one, whatever, they would have equal representation.
Well, Dr. Wilson can correct me if I'm wrong, but I think the way this is envisioned to happen right now is we have a list of 15-ish university employees who have volunteered to be advisors. That list of 15 folks will be handed to both the accused and the accuser, and from that list, they can select the advisor of their choice.
Well, I'm on the record is satisfied with this, but I want to put on the record that with the majority of our students Pell or half our Pell, it's unfair to our poor students because they won't be able to afford an attorney. And if any one of our board members' children, we'd be able to fund an attorney. So I just want to make sure that that it's equal, that one party doesn't have one that the school's paying for, that the other party doesn't. If you can pay for your own, wonderful. I got that. That's my question.
Yeah, point of clarification, the 15 or 17 on the list, either or both parties have the option of selecting as an advisor. And it's our assumption, obviously, if they were not qualified, Mr. Chairman, they would not be on that list. So I think we've speak to your concern with regards to making sure that there is balanced representation on both sides in that regard.
That's good. Thank you.
I want to go back to your question about the 72 hours just for a moment. As I read this, Jeff, it says at least. It doesn't limit or put is that correct?
That's correct. And then I'd also note that the regulations and the policy and the rule also require that the parties be provided the investigation report 10 days, at least 10 days before the hearing. So while the actual witnesses as a witness list may not be disclosed until at least 72 hours before, the parties that the potential witnesses will have been disclosed as part of that investigation report 10 days before.
So
as
why not
well.
make that 10 days instead of at least? I mean,
So,
I don't see the pushback on that.
no, it's not pushback, just a point of clarification, though. It doesn't say they have to
I know
within.
it, but you should assume the worst case. In baseball, you assume the worst case, and the worst case, if somebody is not treated fairly, is you'd wait till 72 hours to notify them. And that's not a deal breaker, but I think there's lots of stuff where, in here, a number of times, where, for instance, on page 14 or 6, the MTSU will provide written notice of allegation potentially constituting sexual harassment, number 2. It doesn't say how many days.
Three-quarters of the way down the page.
Maybe I missed it.
Well, Chairman Smith, I think in that first case, the 72 hours, that is a requirement on the university to quickly inform the people involved. It's not to the detriment of the people involved. It's the university can't drag its feet kind of a requirement. And I think there's some wiggle room or some extensions allowed in bullet point number 6, right below that. So I'm not sure about the consistency across the entire document, but I think on page 17, the intent is appropriate.
I promised. But 72 hours is not enough notice if you're going to have a live hearing. And where it doesn't say how many days, it just says we'll provide.
It's 72 hours for the university to inform the people involved. It's not 72 hours to
it's like
schedule the meeting, the hearing. In other words, I can't, as a university person involved, I can't sit on the facts for 10 days and then tell you tomorrow there's a hearing. I have to let you know within 3 days that there's going to be a hearing, even if that hearing is 10 days out.
Is that the correct interpretation? That's not how I interpret it.
Yeah, it's 72 hours.
Before I'm to appear at a hearing.
That's right. It's 72 hours prior to the hearing is when this information is to go out. And I'll point out one of the difficulties in putting this together is we were trying to marry the new Title IX regs with the Student Due Process Protection Act passed by the Tennessee legislature 2 years ago. And these notice provisions here are the notice provision requirements from the Tennessee Due Process Protection Act. So that's what it requires, the 10 days before where you provide the hearing notice or the investigation report, that's from the new Title IX regulation. So it's part of trying to marry both of those together into this rule and into the policy and make sure we are complying with both is how we ended up.
Last one, on page 6 or 14, whichever one. Number 2, towards the bottom, there's several number 2s. It says you'll provide written notice, but it doesn't say when. Zero
And-
two 0240-07-06-08.
Yeah, I found it here. I'm looking to see if that's an issue that we may have.
We have it twice more on 7, number 4 and number 4. If in course investigation decides to investigate allegations about the complaint, respondent not included, MTSU will provide notice of additional allegations to the parties whose identities are known. Is that a week or a month or a year?
Well, and this is an issue that's fleshed out a little bit more in the policy from the rule. And in the policy, it says upon receipt of the formal complaint. So after the accuser has filed their formal complaint, upon receipt of that, the Title IX investigator provides that written notice. It does not specify that they'll do it within X days. We could add that. But it does specify upon receipt of the formal complaint.
Okay. Nearly every rule that isn't specific, it can be interpreted different. And I don't see the pushback on giving everybody a week's notice if you're going to have any of it, or at least on those, there should be 24 hours in, or 8 hours, or some number. But the devil's in the detail.
And I do see what you're saying about that 72 hours, because it's not, it's that there will be a hearing, and then when MTSU decides to hold the hearing, there's 72 hours, but there's no issue about how long they take, so I do see your point.
The other thing we need to take in consideration is that the university is not always in session. To be careful that we don't pin ourselves down in a point in time that could be problematic for us. For an example, if indeed, a complaint comes in at the end of the semester and folks are not around, so I think we need to take that in consideration. This is just an adjustment in a policy that we have been practicing very much for years and years and years. And obviously, if the board wishes for us to put some specific timeline, we will, but we have not really run into any problems with the number of cases that have come, and we try to be very efficient in responding. But one of my concerns is that nailing down a specific time in some of these that could create a real problem for the university because of our schedule, our timing of operation.
Well, I guess I see Chairman Smith's point that if we're doing a pretty good job of it, we might like to codify some of our rules and procedures that we ourselves do, because none of us are permanently in our positions. So the group of people that are doing it now are doing a really good job. But if person A steps out and retires and person Z steps in, it would be helpful for them to have some general guidelines as to how they accomplish some of this. There are also, as you make the point, Dr. McPhee, there's some concerns about when faculty are involved as part of the process, because faculty aren't on contract every minute of the year, and therefore getting a team of faculty together may take some doing and some time to construct it. So we do have to leave the university the time to make it happen. But if we've got the process nailed, maybe we don't want to reinvent the wheel, we just want to describe it a little bit more.
So may I ask a question? Procedurally, there's a rulemaking hearing scheduled for the Board of Trust for our meeting on September 15th.
Yes.
It's correct.
What will be the context of that rulemaking hearing? What will be the subject matter that will be defined in that?
At the rulemaking hearing, you will take public comment on our rules, which are found from pages 9 to, whenever that ends, to page 22, and the board will vote on whether to approve those rules, that rule or not.
I might also add to your question, Trustee DeLay, that at lunch, because this is a new process with a new board, I've asked an attorney to give a brief orientation towards dealing with the rulemaking process to answer some of the questions. So that is scheduled for our lunch today. Right. So any additional questions you might have and additional information, because this is, again, the first time for this board to be going through the process. And it's a very long, and it involves the legislature, and so we want to make sure that you clearly understand that process.
So for our meeting today, this is an action item that will require us to either vote on or to pass this item.
Right. Now, no changes will be made based on the vote today, but when it comes to the board in September, that's when it can deliberate on any proposed changes.
So let me call the question of, do we have a motion to approve this as presented today? So moved. Do we have a second?
I'll second. Martin.
So let's call the question to vote. All in favor? Aye.
Aye.
All opposed? So
Does motion carry?
motion carries today. Thank you very much. Jeff and Miriam, thank you very much. Our next item is also an action item, which is the annual report for the audit and consulting services. I'd ask Brenda Burkhart, who's our Chief Audit Executive, to present this.
Thank you, Trustee DeLay. Presented for your review and approval is the 2020 Annual Report for Audit and Consulting Services, which is required by state law, the board bylaws, and the board policy on board committees. The report includes a summary of the audit effort for 2020, the status of the 2020 audit plan, a summary of the investigative review activity, a report of the audit office resources, and the audit plan for the 2021 fiscal year. The report is an approval item on the agenda because MTSU Policy 70 requires the Audit and Compliance Committee to approve the annual audit plan, which is on page 6 of the report or page 56 of the meeting materials. That concludes my comments on the annual report unless there are questions.
Brenda, one question. In looking at the financials on page 5, the resources,
Yes.
benefits are $123,000, which would be 42% of the combined compensation. That seems to be awfully high for benefits. Could you explain what's included in that?
I took it from our salary report, but generally our benefits is our insurance, retirement payment, the tax portion. Maybe Alan will help me if I forget something. Isn't that most of them?
Alan, does that seem high? 42% benefits? I mean, that's, the rule of thumb's usually 20, 25%, so.
When we budget a new position, it is usually around 35 to 37%. And all of the state benefits.
And part of that's retirement, right?
Yes, and it depends on which retirement plan you are on as well. That's why we, with a new position, we estimate around 35 to 37, but it can be higher depending on which retirement program you opt in.
Alan, it also includes longevity, a whole series of, and to your question, which is a good question, Trustee Boyd, you know, one of the attraction for state employees compared with business and industry is while the salaries are not competitive to business and industry, the benefits are some of the attractive part of when we recruit individuals. And so I think we need to take that in consideration as we compare salaries and benefits of state and public employees and that of private or business-related employees.
Also in that number is holiday and vacation, correct?
No, that would be in the salary.
Salary.
So if you take it, then
True salary number.
It just never jumped out to me like it did in this report, so I was curious about it, so thank you.
Thank you.
Ms. Burkhart, thank you. Do we have a motion to approve the annual report for audit and consulting services?
I'll make a motion. I'll second.
All in favor? Aye. Opposed?
Could you clarify, I'm sorry, could you clarify
Trustee
who made the
Martin-
the motion?
Trustee Martin made and Trustee Smith seconded.
Thank you.
Thank you very much.
Thank you.
Next, we have a lot of information items. Compliance and enterprise risk management update. I'd like to ask Janae Stevens, Assistant Vice President of the Office of Compliance and Enterprise Risk Management, to present.
Thank you, Trustee DeLay. Presented for the committee's review is a discussion of three components of the university's compliance and enterprise risk management program, namely the university's records management activities, its Drug-Free Schools and Campuses Act biennial reporting, and MTSU's compliance with the European Union General Data Protection Regulation. For records management, the university continues to provide its annual records holding report to the state's Records Management Division by July 1st and continues to receive positive feedback from the state RMD director, Kevin Callaghan, regarding MTSU's work to comply with state requirements. The records holding report for this year was submitted on June 30th, 2020, and included information on the university's records holdings, and that includes paper records, electronic, and other record mediums, as well as the amount of records destroyed. The 2020 holdings report included data analytics, which compared the university's holdings also from 2018 through 2020. The addition of the data analytics served as an enhancement to the overall holdings report. An email communication from the state RMD dated July 1st, 2020, complimenting the university's efforts related to records management is included for the committee's review. With regard to the Drug-Free Schools and Campus Act biennial reporting, the Department of Education requires institutions of higher education to provide information and biennial reporting under the Drug-Free Schools and Campuses Act regarding its alcohol and drug prevention programs, activities, and policies pursuant to the DOE's General Administrative Regulations. The DFSCA biennial report must demonstrate that the university provides annual notification to all employees and students in writing concerning the standards of conduct, appropriate sanctions, and health risks related to alcohol and drug prohibitions and prevention. It must also provide a description of available treatment programs. It must maintain a methodology to distribute annual ALD notifications to all employees and students. And the university must prepare a biennial report on the effectiveness of its ALD prevention and education programs, as well as document the consistency of ALD sanctions and enforcement. The university's DFSCA biennial report for 2018-2020 was successfully completed and has been posted to various university websites in compliance with the DOE. The biennial report details MTSU's ALD prevention and education program, provides statistics related to enforcement from the Office of Student Conduct, Housing and Residence Life, and University Police, and additionally provides information on initiatives that help to provide student support related to the connection between substance abuse and mental health. Finally, and regarding the university's compliance with the European Union's General Data Protection Regulation, which provides European citizens, including EU students, with broad data protection rights, including the right of data erasure, the university's activities concerning GDPR continues to be monitored. Given the low number of EU students, as well as employment applicants, there is still not a need to perform a data impact assessment under GDPR standards. There has been, however, one request for data erasure in 2020 by an individual who received marketing information from the university. And actually, as of last week, there was a second request for data erasure. However, in both cases, the requests that were made were from information that was from 2013 and 2017, for which at the time, the right to data erasure was not included in the EU GDPR. And finally, just for information purposes, the UK left the EU on January 31st, 2020, so we are no longer including the UK as part of our data count. That concludes this public portion of my report.
Thank you, Ms. Stevens.
Do
Trustee
we
Baker.
control the shredding of documents on campus, or do we use a outsourced avenue for shredding?
So we do both, and thank you, Trustee Baker, for your question. Because we are required to document the destruction of our records, as part of our processes, we recommend shredding and cross-shredding if possible. However, to comply with state requirements, we also hold what's called annual destruction days. And we typically handle those days or hold those days every fall, usually in October, late October, to give staff and faculty and employees an opportunity to gather any documents they wish to destroy. Now, they have to document that in our records management database that is proprietary to MTSU. However, we do use an outside vendor who comes in for 2 to 3 days and who takes those documents that have already been designated for destruction and that have already been documented in our database, as well as approved by my office, to be destroyed. And we have to keep track of that because the state requires that. So we do both. Staff and employees and faculty can destroy documents outside of the annual records destruction days, but in doing so, they still must document it in our records management database.
Do you control the purging of scanned files?
So we ask that each employee, especially each department and division, who is assigned a records coordinator, and that records coordinator is usually an employee in the department or division. And so we ask that records coordinator to work with their department and division staff and administration to ensure that anything that they are destroying, whether it is an electronic record that they're purging or whether it is a physical record that they are shredding, that that information is documented. And the same goes for any record that is once paper that is then converted to electronic. So our records coordinators for each of the departments and divisions that are designated have been working diligently and tirelessly to ensure that our database has been updated. And the database was created in late 2017. So, and as you can see from the email compliment that we received from the state director, Kevin Callaghan, he continues to be pleased with MTSU's requirements and the standards that we have set for records management.
Thank you.
Thank you, Trustee Baker.
Other questions? Thank you, Ms. Stevens.
Thank you.
The first portion of the Audit and Compliance Committee meeting concerning public matters is completed, and we'll now go into executive session for discussion concerning risk assessments, audits, and investigations. No business other than these items will be considered during the non-public session. Following the executive session, we will come back into public session to take action on the risk management report submittal. I must now ask that everyone other than board members, the president, our assistant vice president for the Office of Compliance and Enterprise Risk Management, our chief audit executive, the assistant director for audit and consulting services, and our legal counsel, please leave the room. Thank you very much. I'd like to call our audit and compliance meeting back into public session, and I'd like to ask Ms. Janae Stevens to come forward and present 2 additional compliance and enterprise risk management items for information purposes.
Because I know lunch is waiting, I will be expeditious and quick. The two sections that were missed were updates related to the university's annual compliance effectiveness training for FERPA, ethics, and HIPAA. Annually, my office is responsible for disseminating mandatory training on the following: the Family Educational Rights and Privacy Act, which is applicable to all full-time, part-time, and student employees; ethics training, that's applicable to all full-time and part-time employees; and the Health Insurance Portability and Accountability Act of 1996, which is applicable to health services, campus pharmacy, and actually also our speech clinic staff. A supplemental training is also provided on fraud, waste, and abuse, which was developed to reiterate the university's commitment to fraud, waste, and abuse prevention and risk mitigation. As part of the compliance communication from my office, the following details the increases in employee training completions by year. There has been a 68% increase between 2018 and 2019 for ethics training, a 111% increase for FERPA training, and for HIPAA training, a 7% increase. Finally, and in addition to the above increases in annual training completions by employees, the Health Services and Campus Pharmacy Department continues to ensure the privacy of student health records as well as HIPAA-protected patient health information, with additional support from the Information Technology Division. The HIPAA compliance video training is also utilized by MTSU's speech, language, and hearing clinic staff, as well as student clinicians in preparation for their clinic practicum work. This concludes my report.
Thank you, ma'am. Would you also please report on the DOJ evaluation?
In 2020 of June, the DOJ issued additional guidance regarding its evaluation of corporate compliance programs, and specifically the DOJ's Justice Manual outlines factors for consideration in conducting investigations of corporations and agencies to determine if, at any time of any offense, the corporation or agency had an adequate and effective compliance program. From the 2020 guidance from the Justice Manual, the following three questions are noted as fundamental questions. 1, is the corporation's compliance program well designed? 2, is the program being applied earnestly and in good faith? In other words, is the program adequately resourced and empowered to function effectively? And 3, does the corporation's compliance program work in practice? The following information in the report provides a chart of MTSU's compliance program and internal control system in answer to those questions. This concludes my report.
Thank you, Ms. Stevens. Our final item on our agenda today is our risk assessment reporting, and this is an action item. And I'd like to ask Ms. Stevens to present that as well.
In non-public, in the closed session, we provided risk assessments for 2 divisions and the university-wide, which were provided to the committee for their review and consideration and voting, as this information is needed so that we may provide it to the state and to our state audit. That concludes my report.
Thank you. I'd like to entertain a motion to approve our risk assessment and risk management.
So moved. Oh, I'm not on the committee.
So moved.
Do we have a second?
I'll second, thank you.
All in favor?
Aye.
Aye. Opposed? There being none. With that, I'd like to thank you all today, and I'd like to adjourn our committee meeting. Thank you.